Good evening, all ISACA members and guests. It is indeed a pleasure to do this introduction. Let me tell you a little about Mark. Since 2010, Mark has been working as an independent information technology consultant with a focus on IT governance, IT strategy, and business analysis. He has currently 2 master's degrees, an MBA from the University of Phoenix, and from Walden University, a master's in information systems management with a specialization in IT strategy and IT governance. Currently, he is completing a doctorate in information technology at Walden University. His research involves cloud security in Jamaican banking institutions. I want you to join me in virtually welcoming Mr. Mark Simpson, presenting on Jamaica's Data Protection Law 2020.
Yes. Well, greetings everyone. In this presentation, I hope to give ISACA members and guests an introduction to the Jamaica Data Protection Act, which was recently passed by both houses of parliament, and discuss some of the implications for IT professionals and their organizations. Now, I say introduction because it is not possible to cover all the details of the Act in one session. The Act is 123 pages long, there are 77 clauses and 5 schedules. Once the Act becomes law, and it's not law yet because it needs to be gazetted, once it's gazetted, it will become law. But after it becomes law, we expect that regulations and other guidance will be issued by the relevant authorities. These regulations and guidance will affect how the law is interpreted. So what we really hope to achieve today is to present the essential aspects of the Act and the implications for IT professionals. So the screen will show you what we hope to cover. First of all what is personal data. Then we look at the framework that they're establishing in the Act. Then the rights of individuals, they call them data subjects in the Act. Standards for processing personal data. And then we're going to be focusing now on the transition period and the implications. So the Act, the Data Protection Act, is about the privacy and security of personal data. So one of the first questions that I thought we should be clear on is, what is personal data? How do they define personal data? Now, the personal data is data that can be used to identify a living individual and or an individual who is dead for less than 30 years. So the Act actually protects the rights of persons who have died. It includes any expression of opinion about that individual and any indication of the intentions of the data controller or any other person. Now, the Act importantly differentiates between sensitive data and other personal data. I mean, sensitive personal data is a subset of personal data, but it requires special processing. Okay, sensitive personal data is, as the name suggests, it's genetic, biometric data about racial or ethnic origin or affiliation, that's your family origin, political, philosophical, and religious beliefs, trade union membership, physical or mental health or condition, your sex life, including sexual orientation, or any alleged offenses that you may have committed. So that's considered very sensitive data. Now, the law, the Act establishes conditions for processing personal data. Now, any one of many conditions can be used, needs to be in place before somebody can process personal data. The first one, which is important but not the only one, is informed consent. That is, if an individual basically says, yes, I give you the right to process this data, the purpose of the why you need to process the data is for this reason, but apart from informed consent, the other reasons that can also apply. For example, if the data contract is party to a contract, that person needs to, you can do it. Or is any one of the conditions. Most important, if the person needs to protect the vital interests of the data subject, that's the reason for processing the data, and also the legitimate interests of the controller or third parties. Now, in addition, now if you're processing sensitive data, then the conditions are slightly different. You may need written consent of the data subject. You may have it may be a legal right or obligation that the data controller has, again, to protect the vital interests of the data subject, or the data may have been made public as a result of steps. So the processing of personal data and the processing of sensitive data is actually quite different. Okay, so in this section, I really focus on the structure that is going to ensure compliance with the Data Protection Act. Now, this structure is really new and will affect all organizations that collect and process personal data. At the top of this structure is the Office of the Information Commissioner. Now, this office exists in other jurisdictions, but it's new for Jamaica. Now, the main role of the Information Commissioner is to ensure the implementation of the Data Protection Act. Almost all data controllers must register with the Commissioner before they can process data legally. Now, data controllers is a broad term referring to individuals, organizations, and public authorities who collect personal data and can make decisions about how and where the personal data is processed. And this definition of data controllers includes a wide variety of individuals and businesses of all sizes. So not only must data controllers register with the Information Commissioner, but the Information Commissioner has the responsibility to monitor data controllers to ensure compliance, issue guidance that data controllers must follow, and the law actually gives the commissioner, the Information Commissioner, an awful lot of powers. You can just click the next slide for me, please. Right. So I kind of presented here some of the major things that the commissioner can do. They advise the minister. They monitor data controllers. They can issue standards of good practice, which all the data controllers have to follow. They could actually direct a particular data controller to take certain action. For example, if they think that their security is lacking, they could say that, look here, if you want to continue processing data, you must implement this, right? So they also have the right to do on-site inspections or assessments of data controllers, and there are they can request information from the people, from the data controller. So they're really the central body that everybody has to report to. So they have an awful lot of control. Now, the Data controllers you can go back to the previous slide. The Data Protection Oversight Committee is there are people, a lot of persons complained about the authority of the Information Commissioner, and so the government decided that they would establish this Data Protection Oversight Committee. Now, this is a relatively small committee appointed by the Governor General on the recommendation of the Prime Minister after consultation with the leader of the opposition. And the role of the Data Protection Oversight Committee is to hold the Information Commissioner accountable to the public. Now, the Oversight Committee has the responsibility and authority to review and investigate the work of the Information Commissioner and report to the Houses of Parliament. I'm not really sure how effective this can be, because a lot of the information they're actually receiving is actually coming from the Information Commissioner themselves and the reports that they table in the House of Parliament. I think that the main recourse of individuals, data subjects, and data controllers who have issues with the Information Commissioner is likely to be through the courts. So the Information Commissioner is still going to be pretty much all powerful. Right, so I was talking about the data controllers, and they basically are expected to follow the standards that are set out in the Act, and which I refer to in other slides in the presentation. And data controllers who process personal data on a large scale must appoint data protection officers. Now, the role of the data protection officer is really critical in the governance structure, because they are to ensure that the data controllers protect the rights of data subjects. They are to notify the data controller of any breach, and of course they need to put that in writing. And if the data controller does not address the breach within the time specified in the regulations, then the breach needs to be reported to the commissioner. In any event, the law specifies that breaches must be reported within 72 hours. So the data protection officers are kind of like the compliance officers within the data controllers business. They're employed by the data controllers, but they also have a role in terms of liaising with the Information Commissioner and providing reports to the Information Commissioner. And the other thing that they need to do is to assist individuals, clients of the data controller, to ensure that their rights are actually protected. So they are very critical in the process as well. Apart from the data protection, the data controllers and the data protection officers, I just want to speak a little bit about what the Act refers to as data processors. Now, the data processors are external parties that process data on behalf of data controllers. So, to give an example, the most obvious example to me is cloud providers, cloud managed service providers. They process on behalf of the data controller. So a bank has data in the cloud. The cloud is run by the managed service provider, the cloud provider, and they may not even necessarily be hosted in Jamaica. So they are external parties. Another example of an external party is, say, external auditors or external accounting firm who does work. We have a lot of accounting firms, for example, who do work for a lot of clients. but they don't actually, although they process the data, they don't actually collect the data. So those will be referred to as data processors. Now, the important thing about data processors is that the data controller must establish a formal agreement with these data processors. And in that agreement, the data processors must agree to basically abide by the Act, the Data Protection Act. It might be reporting data breaches, it might be all the things that apply to the data controller through the Act would therefore apply to the data processor through the agreements that they make. So that's the basic structure. So I now want to turn to the rights of individuals. So you can just advance to that side. Now, one of the purposes of possibly the main purpose of the Data Protection Act is the whole privacy rights of individuals. And these are specified in the Act, and I'm presenting them here. Now, the first one is the right to be informed of personal data by the data controller in the prescribed time. And usually when the Act speaks about the prescribed time, the expectation is that once they put out the regulations would actually specify what that prescribed time is. So the Act doesn't, in all cases, specify what the prescribed time is. So this is another case in point. Now, the right to be informed is important, and that information that the data controller must provide is the actual data that is collected, the purposes for which it has been collected, and the purposes for which it is being processed, the class of recipients who also have access to that data, and importantly, the sources of that data. The assumption is that not in every case will the data subject be the source of the data. In fact, the data subject may be wondering where they got the data from, but they have a right to find out. And so that's the right to be informed. A second right is the right to request that their information be transmitted, their personal data be transmitted to another data controller. So that is something that is possibly new in Jamaica, but organizations could be requested to transmit certain data from their database to another organization at the request of the data subject. So that is one of the rights that is given to them. They also have the right to prevent processing. Now, before we looked at some of the conditions under which data controllers can process data. And one of those conditions was informed consent. Now, if you're processing data based on informed consent, then the data subject has the right to withdraw that consent and therefore prevent processing. And even if they are processing on the basis of one of the other conditions, they could actually, write to a data controller and explain why they no longer wish their data to be processed. In fact, they want their data to be removed from that data controller. Now, the thing about all of these rights that are established in the law is that they're subject to actually many exemptions, which I'm not trying to address because there are many and it would take us a long time to go through. So one of the things that persons who are operating in this new regime is that they have certain rights, but they, for example, if informing somebody of if they request the information on their personal data, But if providing them will compromise somebody else's personal data, then they may not be, or it may be under a court order or something like that. Then you even though they've requested it, you will not be able to give them. But it's important to know what the rights are. Later we can learn about some of the limitations on these rights. Data subjects can request that decisions that affect them, like work performance, creditworthiness, reliability, conduct, should not be based solely on automated processing of personal data. Sometimes I think the feeling is that if they just if they automate everything and eliminate the influence or the introduction of evidence that they have or relevant parties have, then they could end up with a poor reliability score, a poor work performance score. And finally, they have the right to rectify any inaccuracy. So tied to the right to be informed, if the information that they realize that is being used as to process their data, if they recognize that there is some inaccuracy in that, they have the right to have it corrected. And the data controller, based on, I mean, obviously, if you're changing something, you're going to need some evidence and so on. So once all of that is provided, then they also have the right to, to correct any inaccuracy. Yeah. Okay, so the next section, I want to just focus on the standards for processing of personal data. And these apply to the data controllers and the data processors. Now, personal data shall be obtained only for one or more specified and lawful purposes. So once you're processing personal data, the reason why you have that, the purpose for that getting that data must be clear, and it must be lawful. And it shall not be processed in any manner incompatible with those purposes. So if you get data from a data subject for, say, opening an account or whatever the purpose is, you could not use that data in any other way and for any other purposes. So once before now, you collect data, very often you don't really specify what the purpose is and there's no limitation. Now you have to specify what the purposes are. It must be lawful purposes, and there may be other lawful purposes in it, but because you did not specify it, you could not use that data in a manner that is incompatible with the stated and agreed purposes. So this is important. A second standard is that personal data relevant and limited to what is necessary for the purposes for which they are processed. So once you establish a purpose, right, that almost establishes the scope for the kind of data that you can actually receive. Because if you're getting data and it's not, it doesn't appear to be relevant to your purpose, then why are you collecting it? This is data that doesn't really belong to you. It's the data subject's data. So you should only be getting data that is adequate for the purpose, relevant for the purpose, and limited to what is necessary for that purpose. And it's an important principle in the Data Protection Act. The data, as far as possible, should be accurate and where necessary kept up to date. Now, a lot of personal data like ID information has expiry dates and stuff like that could be inaccurate. People change their name. So maintaining the accuracy of the data is not going to depend on the data controller alone, but the data subject also has a role to play in ensuring that the data remains accurate and up to date. And this is why the data subject also needs to be aware of what the current state of the data is. Now, personal data process for any purpose shall not be kept for longer than is necessary for that purpose. There's only one proviso in some cases, depending on the purpose. You really could keep the data for an extended period of time. Lots of persons open accounts and they have those accounts for years. And as long as they have the account and it is being processed as required, then they can keep that data. But the point is that depending on the purpose, the time with which you keep the data is determined by the purpose. So once that purpose expires, it's no longer being used for that purpose, then really you should not be keeping the data. And if there is unless there is some enactment in law or whatever that says, sometimes the organizations have what they call retention policies, where you need to keep certain data for 7 years or whatever the time period is. So so that would also apply. So you can't look at this just in isolation. You have to look at it in keeping with, in terms of the other laws that apply. Appropriate technical and organizational measures. And this is the standard that speaks to the data security standards and other organizational measures, the governance and other things in place to secure the data. In some cases, it might require masking the data, encrypting the data, using the latest security technologies, using the latest security governance measures. So this is what will affect a lot of IT professionals to ensure that we have the appropriate technical. It must be using the latest technology, and the standards are actually elaborated further in the Act. So that's an important standard. And the final one that I mentioned here is processing outside the country is allowed, provided that the external country has a similar legal protections. And this applies to particularly where data processors are involved. And as I said, cloud providers is a good example, where sometimes the organization really doesn't know where their data is really being processed. And sometimes they don't care, but sometimes what this law is saying is that you need to know and you need to care, because if it is being processed or held in a country that has similar legal protections, then there's no problem. But you can't make that determination if you do not know where it is being processed. So part of the agreements with the data processor is to provide that information and for you to audit so that you know where your data is being held. And you can make that determination about whether, and I think the Information Commissioner also will have some say in terms of what country is considered appropriate legal, that provides appropriate legal protections. So that's actually can be that's a kind of change. A lot of times now data is being processed and you really, you have a Google account, you don't really know where the data is being stored, but you provide all kinds of information on the internet. And right now you really have no clue where the data is being found. What this act is saying is that if you're a data controller, you need to know and you need to monitor it and you need to ensure that the country has similar legal protections. It's kind of like a standard, but this is reporting breaches to the Data Protection Act. And when I speak about reporting breaches, there are two categories. This is any contravention of the data protection standards. In other words, if you're breaching the act itself, then that needs to be reported within 72 hours. And it also relates to security breaches. In other words, if there is if your data was somehow compromised through the network or however, then the data control has a duty to report to the commissioner within 72 hours and to indicate the affected accounts or the affected, the data subjects that have been affected. And there's also a duty to notify the affected data subjects whose data has been affected by the data breach. Again, it talks about within the prescribed time, but the actual details of that, I presume we will know once they issue the regulations. So reporting breaches is, so one, you need to ensure you have the right security in place, but then we know that with the whole, there's always a risk of, data breaches, and almost every day we hear of other data breaches. And I think the Act is really trying to ensure that persons put in the appropriate controls to ensure that they reduce the risk of data breaches. But where they do happen, then they need to be notified, and the data controllers need to be notified, and the data subjects also need to be notified. Okay, so the transition to the Data Protection Act. Now, the Act itself allows a 24-month period after the Act becomes law before it will be enforced. And this period is, and I don't know if it's going to be enough, but in most other countries that have modeled, well, even the European data protection regulations, which was passed in 2016, they had a 2-year period, so it only became effective in 2018. And that seems to have been the trend in most other countries that have data protection laws modeled off the EU's GDPR. But then they need to do a lot within that period. They need, well, the authorities need to set up the Office of the Information Commissioner. They need to decide who the Information Commissioner is going to be. Once they decide the Information Commissioner, that person has to staff their office. They need to find out where their office is going to be. They have to work out, their procedures. They have to begin, can remember everybody has to be registered, so they need to begin registering people. So it's going to take a fair amount of time before the institutional framework is actually put in place. And the good thing about it is that it allows data controllers and other individuals 24 months from the law is enacted to and a little time before, which shouldn't probably be less than a month. So until it is enforced, there's a lot of things that organizations and IT professionals need to do. Now, I begin to list some. I'm not sure if it is exhaustive, but I've begun to suggest some of the things that need to be done. And as I think Kirk had also mentioned, you can just go to the previous slide, please. Right, so increasing knowledge and awareness of the Act, the regulations, and any guidance. Now, the Act is passed by the Parliament. The regulations are under the Act, the Minister, I think it's the Minister of Technology, can issue regulations, and the Information Commissioner can issue any other guidance. Now, organizations and professionals need to be aware of all of these, right? The second thing, as a subnote under that, I highlighted that it's not enough just to know the rights of people and the rights of data controllers, but the constraints, the limitations, the exceptions, because it's a pretty complex law. There are lots of exceptions, so that if you apply something when you should not apply it, then you could find your organization in legal jeopardy and be liable for things that you really don't want them to be liable for. Another important action is to identify the person for the role of data protection officer. Now, one of the issues with data protection officers is that you don't want to have conflicts of interest between probably the existing role and the data protection officer role, because they're really like compliance officers or auditors, and they need to ensure that the institution is actually acting in keeping with the law. They're the guardians of the law, you know, acting basically in the interest of the law and in the interest of the country. So they need to have a very clear idea of the law itself and all the ramifications, the limitations, the constraints, so that they can advise data subjects about the law. So they can be given a role, but they're going to need a lot of time to prepare themselves for this role. So organizations need to start identifying, probably a set of persons who can possibly fulfill this role. Later on, they can officially appoint them. They probably need to be documenting some of the procedures that they need to follow and the rest of that. So that's another thing. Now, the Act itself, as I said, it introduces a new framework and has different aspects to it. So one of the things that organizations need to do is to identify any process and policy changes that are necessary to ensure compliance with the law. People may have policies about maybe they don't need to inform people, they need to change that policy. So you'd have to basically look through all your policies. What are the things that need to be changed? Audit programs need to be updated to reflect the Data Protection Act and some of the controls that need to be in place and to ensure that they're checking for those. Enhanced security measures. Some organizations may be up to date. I suspect many are not. So at least they need to review the security measures that are currently in place and possibly make plans for enhancing these. Of course, there's costs associated with that. Moving to the next slide. Obviously, there's going to be a cost for this transition, and the cost I suspect will be probably a little more heavy on the side of the small businesses who may not have up-to-date technical measures and various other things. But nonetheless, even for the large companies, I think there's a cost for this transition. I mean, you now have to have somebody dealing with the information commissioner. You're going to have to ensure that your security is in place. You need to have your data, all kinds of things that need to be put in place. Your legal team needs to be aware of the Data Protection Act and all that entails. So developing a budget for this transition is just one thing. It's almost like a project. You need to develop procedures for ensure timely reporting. Again, this might be just a change in procedure or just basically how it is done, just to ensure timely reporting, because if the thing, you may report it, but it's after the 72 hours and then you're subject to fines and penalties. And therefore, you don't really want that. When they're putting forward the Data Protection Act, and it does carry some heavy penalties, but the point is to comply with the Act and not really get yourself subject to penalties. And the way to do that is to do this preparatory work during this transitional period. Once, if there are data breaches, for example, apart from contacting the commissioner and the affected data subjects, usually, there needs to be some protocols for public communication. Those need to be established. I'm not sure if there's any. I don't recall anything in the Act that talks about public communication, but it's something that you may wish to consider. The other thing I noted is reviewing the privacy policy to ensure compliance with the Act. Now, a number of companies have recently reviewed their privacy policy to make it compliant with the General Data Protection Act from EU, and they probably should be okay, but it is wise to once again review that policy to ensure compliance with the Jamaican Data Protection Act. If something does happen and the availability of privacy of personal data is compromised, you're going to have to look at what are the measures in place to restore the availability of that data in the shortest possible time, because confidentiality, integrity, and availability are critical factors in the security of data. Another implication, then something that must be put in place by pretty much all organizations, and again, you need to start putting in place these measures during this transition period. Regular testing, assessing, and evaluating the effectiveness of technical and organizational measures. And that needs to be a routine that is done periodically. And that's something that is going to involve, well, many IT professionals in that. I also, the other thing I don't have here, but it's something that I probably needed to add, is that organizations need to review their agreements with vendors and the data processors to ensure that they are also compliant with this Data Protection Act. So that almost certainly is going to be some action item that they would need to perform. Now, the Act is about giving rights to data subjects, and I presume that the government will have some kind of education program. But it strikes me that each organization also needs to probably think about educating their own data subjects in terms of how they are implementing the changes. So that, I think, is also important. And treating it like a project and developing what I would call an implementation checklist, which is a list of all the various things that you need to do. And we're not the first who is, first country that is going this route. I think ISACA has resources about our implementation checklist. Other countries, even within our region, have also had the experience. I think Barbados, Bermuda, Cayman have, and so that it is possible for us not to just start from scratch, but to rely on but utilize the experience of other countries in building these implementation checklists. It's a big change. It's an important change, and we need to be prepared for it.